The SEC filed a final-ditch petition. We'll go over the highlights of the submission in this video because it contains some nuggets demonstrating the SEC's continued total hypocrisy. We'll also discuss the SEC's justification for actually filing this numerous attorney case last night in an attempt to persuade Judge Torres to allow them to appeal her ruling in the Ripple SEC case. Given that the Secretary's prospects of actually succeeding in this appeal are already limited, we're going to explore the Secretary's genuine intentions for doing this because they included information in their brief that pretty well indicates their strategy in this case. In the video, we'll talk about it, as well as the varied perspectives expressed on Twitter by all of the legal professionals on this decision. Make sure to stay for the duration of this event, because there are several incredibly important details in this wish to get straight to the law. Justifications for this SEC's filing of this appeal are stated at the opening of this video, and you see, to file an appeal in a case, the matter must generally be completely resolved. We are currently aware that this case will be tried. Technically, the SEC should have waited until the trial was completed before submitting a usual appeal. Nevertheless, the SEC is filing an urgent appeal here. It is best recognized for interlocutory appeals. As a result, they must have a compelling reason for requiring an appeal. The SEC asserts right immediately in its brief, which was recently submitted to Judge Torres, that the major reason they are currently in need of an appeal is partly because Judge Torres' ruling was so broad. They claim that Judge Torres' order was so broad that it is currently confused. We'll talk about whether that makes sense when we discuss the market actors that are causing a lot of uncertainty. I'll get to it shortly, but first, let me go over something Bill Morgan just stated, since it's critical to understand without going through his full Twitter thread. Bill Morgan thoroughly studied this SEC's stance and determined that the SEC is fundamentally bent by Judge Torres' judgment, which the SEC is concerned about since Judge Torres was quite specific in how she applied the WHO test. The SEC is seeking to downplay the fact that Judge Torres applies the How test with considerable specificity in each of Ripple's sales by misrepresenting her decision and arguing it is overly broad in this appeal. Please request that the SA act in this manner, principally because it recognizes that it lacks legal reason for contesting Judge Torres' ruling. The SEC should not be able to challenge this right now because Judge Torres was so thorough and applied the highway test to each of these purchases. The SEC skillfully twists Judge Torres' decision in this appeal request by claiming that she was not explicit. I believe Bill Morgan has heard where she belongs, and I believe you are having trouble with your appeal. Related arguments since you misrepresented the court's legal conclusion and wish to appeal, he added. The SEC is experiencing problems with this approach. It states that the SEC is probably not on the right side of the law in this matter if they are distorting Judge Torres' judgment, and I think it's important to start here. The SEC is currently requesting an unusual circumstances appeal because they are aware that they are in severe trouble, but Bill Morgan is making the point that you don't need to falsify the facts if you're on the right side of them. In this situation, the SEC is twisting the truth. Let's move on to some of the SEC's most strange statements in this brief because they are blatantly breaking the law. Some of them, in my opinion, were entertaining. The SEC surely accuses Ripple of prolonging the legal processes to waste its resources. This was the initial charge. According to the SEC, Ripple is attempting to prolong the litigation process. We are aware that the SEC has continually postponed this case to continue selling XRP. Ironically, they are the ones who are appealing this case. This adds to the delay, thus it is one of the most paradoxical ever made assertions. This exposes the SEC's hypocrisy and lack of strict regard to the law once more, as the court claimed that simply including something in a brief is beyond the scope of the legislation. There is absolutely no way for me to pass judgment. Torres will not notice and smirk at it with the agency. They genuinely demonstrate full narcissism in this, and they simply expect that since they are the SEC, the court will agree with them if they believe they can get away with saying certain things. According to them, this is one of the hottest stories trending on Twitter right now, and it was quite bizarre, as you may recall. I indicated at the start of the film that the second is requesting an immediate appeal because they believe Judge Tor's judgment has created ambiguity in the market. Stuart Aldera, on the other hand, draws attention to what should be obvious in this situation. After years of the chairman declaring the regulations are clear and running around the SEC, he is suddenly yelling that an appeal is urgently needed to solve these not illegal concerns. Essentially, the SEC has always claimed that the regulations governing all of these cryptocurrencies are fairly clear. Companies must follow the rules, and the situation is now critical. Because there is immediate legal uncertainty, they should be allowed to appeal. Concerning cryptocurrencies, it's a complete farce, but it's important to note that the SEC has presented a variety of arguments for this move that don't add together, so I'd like to concentrate on that. As the second point, I'd like to emphasize that we made it extremely clear that the SEC should not be allowed to appeal because they'd violated the law. On the majority of these issues, especially given how they've been presented until now in the market, they're manipulating Judge Tor's remarks in an attempt to appeal. But what compels the SEC to appeal? This isn't a footnote because, in my perspective, it just describes the section's business plan. Ripple triumphed in the Ripple SEC litigation on practically all critical problems, and the SEC is currently feverishly attempting to hold Ripple accountable by using litigation as a stick. Because Judge Tess has sided with Ripple in practically every key issue, the SEC now has no negotiating power in the settlement talks between Ripple and the SEC. They have no clout, so the SEC needs something to reclaim some leverage. They admit it right here, but that is what they are. Aiming to achieve with this appeal, the SEC is using this appeal as a weapon, attempting to reach Ripple and threatening them with additional legal action if they do not settle. Who knows if Ripple intends to resolve this debate right now? In reality, they want to force Ripple into a contract that benefits them more. The other point I want to make is how likely this is to succeed. How likely it is that Judge Torres will grant this appeal, and how is virtually every XRP. However, rather than simply showing you what they are saying, the community lawyer I have seen believes that the SEC will not be successful on this appeal. I wanted to show you what Mark Fagel had to say about it because he has been on the other side the entire time and has practically agreed with them, he said. Said he believes it will be extremely difficult for them to succeed in having this granted, and that meeting the conditions for a successful interlocutory appeal will be challenging. The facts are now against them, and I believe this is significant because Mark Fagel would probably side with the SEC if anyone did, even if he is unwilling to support the agency's interlocutory appeal that was filed, so the agency has little evidence of a high standard to clear and is most likely merely speculating. Allow me to use this legal action to drive Ripple into a settlement. Just state right now that if I can figure this out, and attorneys on Twitter can figure it out, Judge Torres will be able to see through what the SEC is trying to do. There is no doubt in my mind about that, and if I had to guess, I would say that Judge Torres would reject the Secretary's appeal and take the opportunity to explain why other cases are unrelated to this one. The Secretary's sole defense in this appeal was that other courts have held that other cryptocurrencies might constitute securities in certain situations. Consider the library example and the Tarot Lumic case. However, all George Torres will be able to say in this situation is that your appeal is dismissed, and as a result, XRP is distinct from Terra Livi. This is pretty significant and one of the major sources of uncertainty in the market at the present. Is this, and let me just say right now that I believe the SEC will be ruined if it loses on this issue and the case goes to trial. A trial will not take place for another year and a half to 2 years. We'll most likely have a very different SEC at that point, as well as a completely different SEC chair. Additionally, by that time, Strzok will have had clarity for 2 years or something. Therefore, there is simply no chance of an appeal at that time, either feeling that Judge Torres' decision to reject the SEC's decision is correct or not. Based on what I've seen thus far, the motion will be announced in the next month or two, but I doubt that SEC will prevail. This appears to be the SEC's final attempt to coerce settlement, which I sincerely doubt will succeed. Despite this, the SEC has no leverage, which is extremely fascinating. Once again, it's entertaining to see the SEC function hypocritically, and sticking to the wallet is honestly anyway, gents. I truly appreciate you. I hope you enjoyed this update while you were here. If you did, please remember to like and subscribe.